Thank you very much, Mercy, for that introduction. My profile was up earlier on, so I hope everyone remembers me from then. I'd like to introduce our panelists today and thank them for coming. I will start with Senior Counsel John Ohaga, as we can all see him in person and on the screen, which is a nice change. We've seen many people only on the screen, so welcome, John. As I said, John is a Senior Counsel and the Managing Partner at OK law firm. He's also a chartered arbitrator and has been a successful arbitrator and a mediator and also a litigator in his many years and career so far. John Ohaga was also recently appointed as the chairperson of the National Steering Committee for the formulation of ADR policy by the Attorney General of Kenya, and has many, many more accomplishments we could talk about. Welcome, Mr. Ohaga. If we could have the next profile. Our next panelist here today is Honorable Caroline Whittaker, and she is a principal magistrate with the Kenya Judiciary and presently the Vice President of the Kenya Magistrates and Judges Association. She currently serves as the Mediation Deputy Registrar in Court-Annexed Mediation as the Secretariat in Nairobi and oversees the use of mediation as an ADR mechanism under the umbrella of the court. So I hope we'll hear lots about how that's going and your insights in that. She was admitted to the bar in 2006 and was in private practice prior to joining the judiciary. So hopefully we'll get a little bit about that time of your life as well. Thank you. If we can move to the next panelist on screen. Desmond Odhiambo is a partner at Cliff Decker Hoffmeyer. And this is a leading African law firm. He has over 10 years experience in providing dispute resolution services, has worked in insolvency-related work, and is also an arbitrator and recently a mediator as well. So it'll be interesting to hear his perspective on that as well. Welcome, Desmond. And finally, Honorable Justice Visram is a retired judge of the Court of Appeal. He was the former Court-Annexed Mediation chairman and one of the founding members of it. Incidentally, his core team that he worked with are all here with us today. And so it'll be interesting to see how they share their experiences and feed off each other in terms of that conversation. He is also a member of the International Conciliation and Arbitration Board that practices mediation globally, which is a faith-based mediation organization. And hopefully he'll be able to share a little bit about that experience with us as well. So welcome, Judge Visram. So to get us started, I want to start at the very basic, and I want this for people who are listening in, who are not with us here today, and the many students who are with us here today. I want to start off by asking Desmond, why mediation over arbitration or litigation? What is it about mediation that makes it special? What are the key differences between that and the other forums, in your opinion?
Okay. Thank you, Alim. Yes, I think that is a good place to start because many times we assume that the audience understands what mediation is. But for the business community, what mediation is you have a third party that facilitates negotiation between the disputing parties. And the difference between mediation and litigation or arbitration is that the mediator does not make a decision at the end of it. And like a judge will hear, like a judge will hear the facts, admit evidence in a formal process, and then give a decision at the end. The mediator merely facilitates the parties in negotiating. So the reason why mediation is attractive and has a good success so far is because it's a win-win situation. The parties are able to co-create a solution. It is the judge coming up with a solution based on the facts or on the law. The parties are able to explore more than what is available. So if I was to give an example, if there's a dispute on a contract, a judge or an arbitrator will be looking to see what rights or remedies exist under that contract. He's limited to the provisions under the contract or under the laws of contract. But in a mediation process, the parties are able to go beyond that. They might decide that they want to negotiate a whole different contract altogether, or maybe renegotiate the terms. And that scope is not available in an ordinary litigation process.
Thank you, Desmond. As a quick follow-up to what you said, it sounds to me that this process is a lot more informal than litigation. What happens to the advocate in this scenario? What about the role of the advocate? Because we have lawyers here today, and many of them have been concerned about what mediation means for them. What's your take on the role of the advocate in this particular process?
The advocate has to wear a different hat. I think when mediation started, it took a long time for us advocates to sort of change our mindset. We are trained for battle, you know. We are used to the adversarial system where we go to win. But in the mediation process, the advocate is more of an advisor. And so he should take a backseat approach and let the client, you know, explore the situation at hand and explore the issue at hand. So he shouldn't take over the process and do most of the talking. His role is more of an advisory role. And also before the actual mediation starts, it's important for the advocate also to prepare the client and just to explain to the client what mediation is about, and to encourage the client to fully participate in the process, and to, you know, inform the client that, you know, they can't just send the advocate. They have to be on board. And if it's a corporate organization, the advocate must ensure that he gets somebody who has authority to actually settle. Because one of the frustrations is that you spend maybe 2, 3, 5 days in a mediation process, and the advocate on the other side, or the parties on the other side, say they don't have authority to settle. They have to go back and take it to somebody higher up in the organization. So which, you know, frustrates the mediation process. So I think the advocate has to wear a different hat. Yeah.
And senior counsel, do you think this requires a overhaul of our cultural understanding of litigation and mediation? Do we need to overhaul the way we do business, or the way advocates are traditionally used to doing business? Does court-annexed mediation require a change in culture for that to happen?
Yeah, that's an interesting question. I mean, as Justice Visram will attest to, when we conceived the whole court-annexed mediation program, we recognized right from the outset that the advocates would be the biggest stumbling block. And so we set out to train and to change their mind frame. And that was quite a steep climb. But I think we're getting there. We're leveling out now. And I think there's a greater appreciation. But back to the gravamen of your question. For me, the entire concept of mediation, and particularly the entire concept of court-annexed mediation, should ingrain in our minds, in our thinking, a complete culture change in our approach to dispute resolution. Because, you know, previously, before the advent of court-annexed mediation, and maybe even before the advent of arbitration, because even with arbitration, in my earlier years in practice, there were very many judges who were reluctant to send matters to arbitration. But because court-annexed mediation means that when you file a suit, you never know whether it will be tracked to mediation or not. And when it is, you have to go to mediation. It means that there is more and more advocates, parties, litigants being exposed to mediation. And so what that is doing is exposing us to the fact that there is more than one doorway to the formal, let me say the formal dispute resolution process. And it is that culture change that mediation will bring about. Today in the previous panel, we've heard about, you know, staircase processes. Previously, those were not thought about. Commercial lawyers, parties didn't think that you could commence a dispute resolution process firstly by negotiation, and then mediation, and then arbitration. Arbitration was accepted as one that potentially would be available, but the only real doorway was litigation. So my whole hope is that when this court-annexed mediation achieves maturity, that we will recognize that we don't have to go to court to go to mediation. And so what that will do eventually is to begin to grow commercial mediation in the same way that commercial arbitration has grown, so that parties will opt to go to mediation without having to go to court, and therefore unclog the number of cases that presently we find in our courtrooms. So it is that complete mind frame, that change in our mindset, that I think would be the greatest benefit from the court-annexed mediation program.
And as we make this cultural shift and we say to ourselves that we can now go ahead and we can mediate and we don't need to go to court, how do we ensure standards in the industry? How do we govern the mediators and ensure that we're going to get the same sort of standard of care that we get from lawyers?
Yeah, that's interesting. Wearing a different hat, I also convened the ADR committee of the Law Society of Kenya. And I also chaired the accreditation committee of the court-annexed mediation committee, as well as the Nairobi Center for International Arbitration. And so I look at it from both sides. And looking at it from the perspective of advocates, one of the things that we have deliberately done is to have forums at which we are constantly talking about mediation, constantly talking about what are the new, what should we be talking about? What should we be looking at? For instance, with COVID has come virtual mediation. And so we have to sensitize advocates to the possibility that mediation can be undertaken on a virtual platform. And the reason why we consider advocates to be important in this chain is because advocates influence their clients. When clients come to advocates, in my view, and I think this is the reality, they are prisoners of their advocates when clients come to an advocate, and they take the advice of their advocates. So if the advocates are up to standard, shall we say, are aware of what virtual mediation, for instance, is, or what the new strategies are in mediation, then they will sensitize their clients. Now, from the perspective of mediators, what we do is that we require mediators to ensure that they renew their accreditation annually. And what that does is to give us an opportunity to ensure that mediators are continuing their education, that mediators achieve a certain number of mediations before their renewal comes up, that mediators who are not able to undertake mediations during that period find some continuous learning programs that they can engage in order to ensure that they remain abreast. So that way we are sensitizing both sides. Now, through the judicial side of it, the task force on court-annexed mediation, and I hope that Madam Kenago will speak to this. The other thing that we have considered doing is finding public forums, radio, TV, social media, where we can speak directly to users and talk to them about the benefits of mediation, what's happening in mediation, and why mediation. And you will have seen that there is more and more articles in the newspapers. The Chief Justice is constantly talking about mediation. Other judges are constantly talking about mediation. And there is a real embracing of mediation in the judicial family. And so we are looking at every touch point to ensure that everybody stays abreast and that mediation is properly ingrained as part of our dispute resolution processes.
Fantastic. So there are standards being developed, maintained, there is sensitization ongoing. The next question would be then, for Your Honor, what kind of cases end up in mediation? How does the screening process work? And what sort of cases do you refer to mediation and believe are suitable? And maybe then you could also tell us a little bit about the ongoing policies regarding court-annexed mediation at present.
Thank you very much. Thank you very much, Aline. And indeed, I am very privileged to be in this panel with giants whom we really have stood and continue to stand very tall. The conversation around court annexed mediation has been a journey. So for us to be able to get to a point where all of us are picking up and not just looking at it, that it is a business of the court in terms of the success and the implementation of the same, for us is very critical. So allow me maybe to just start with the question around the legal policies and the issue of conversations, a futuristic approach in terms of where we are hoping we'd get to be. Is in terms of the legal framework, we are looking at reviewing the mediation, hoping to come up with the mediation rules. We have been using practice directions, and the main reason that the judiciary and the team that led us at that particular point was just mainly to be able to look at what kind of a model are we looking at for the implementation of mediation. So there was no rush in terms of picking up a model that is perhaps borrowed from the other ADR practicing countries, but more in terms of a model that will cater for what the special nature of the cases and the special nature of the courts that we also have. In terms of policies, we have a number which I think have been mentioned by senior counsel. We are looking at reviewing the code of ethics that we currently have. We also have accreditation standards which govern the accreditation of mediators, with a shift now towards a bigger picture on the quality of the mediators that we are having. So we are coming in with mentorship guidelines that will help us govern a framework or just provide policy in terms of those mediators that are accredited but come in under mentorship before they can get an active status and we can assign them matters. We're also looking at the issue of the quality of mediators in terms of a harmonized training curriculum, which would also inform policy in terms of accreditation and the kind of mediators that getting. A futuristic approach is we are hoping that with the new rules coming in, and largely looking at the ADR conversations that are going on both in the National Assembly and in the Senate, that would then, out of the learning curve that we have had in mediation, would be able to inform or advise in terms of more of a framework that would be more facilitative for court annexed mediation and as well as the other ADR mechanisms, as opposed to restricting and at the end of it, disenfranchising those who actually have benefited from it. There are quite a number of ongoing conversations also on policy. One of them that I know has been very close to our mediators is on the issue of payment. And the streamlining of it, so that even then, as we look at, or rather talk about the benefits that we have had in mediation, would also be able to give our mediators remuneration or payment in terms of that value that they give to us. We're also having conversations around policy and a structured more of like how do we approach the issue of remuneration of advocates, so a futuristic approach in terms of a legal framework. The bar and bench committee that has been set up are first because all the other bar bench committees that we've been having have been largely around general areas of practice in our different courts. So currently we have an ADR bar bench committee and with conversations towards even bringing in mediators on board. So that committee is looking at a document that we're hoping would be able to present to the task force and subsequently have dialogue with the LSK and conversations around the amendment of legislation to be able to, the remuneration order, to be able to make provisions on a schedule for payment of fees for advocates, while at the same time looking at the schedule for payment of fees for mediators.
Wonderful. On the cases part, which sort of cases are primarily ending up in mediations, and which ones are the most successful? So where do we see the most cases being settled by way of mediation?
The family division still records a very impressive success rate in respect of the matters that are referred to mediation, not just by the referral of courts, but we're also getting in very many requests by advocates, by clients themselves, asking that they'd like to participate and benefit from court annexed mediation. In particular, would be succession cases. And we also have the children court that is also under the family division. We also have a very impressive uptake of mediation in the employment and labor relations courts, and then followed by the commercial disputes that we have, civil, and then down to the environment and land court, where we're having conversations with them to encourage uptake and the resolution of matters through mediation. In terms of what we look at for the screening and referral of the matters to court, when we started, we had almost come up with a very long list, which almost meant that almost all the cases that we had or we have would not have qualified for referral. Down now, an approach of all the cases that we have are actually amenable and they are suitable for resolution through mediation. So the ones that we exercise caution in the referral is cases of public interest litigation. We also have cases of pure issues of law. And then there was some was mentioned about cases that have criminal elements or inclinations towards it. And then with particular also conversations around for children matters and generally family matters, if there are any issues regarding gender violence or domestic violence, child abuse, then we don't refer them to mediation. And then the last is that, of course, we're also very keen that we don't refer those cases where the contractual obligations require the parties had agreed to a different ADR mechanism. So if they proposed in those obligations that they'd like to go through arbitration, then we do not refer them to the mandatory process of mediation unless now it is through their consent and direction subsequently in court.
Wonderful. Thank you very much. That gives us a huge insight as to why our matters might end up in mediation and which don't. One of the interesting things you talked about is payment. And I know for advocates, ADR was associated with alarming drop in revenue, which I've heard of time. It's good to hear that we're working out how to remunerate the advocates. Moving to an area, Judge, where typically mediators are not paid at all, is in relation to faith-based mediation. And I know that personal experience in here, and maybe you can share some insights with us about faith-based mediation, particularly the ethics in mediation.
Thank you for this opportunity. And I'm old, not in age, but old in a period of time that we've spent being today. This having started 20 years ago. On that time, a wonderful girl, very long journey. It has been a productive journey, and I'm happy where we are today. I'd like to with you. And Senior Counsel talked about external change, which is because everywhere in the world, and Kenya is no exception, there has been strong resistance to mediation, especially by advocates, by lawyers around the world. Kenyans are no exception. They may be a little worse, but they're no exception. It's like Alim said, to them it really meant alarming drop in revenue. And that's not it. But we've gotten really far, and thanks to the LSK, thanks to people like the Senior Counsel here, who around 10 years, 5 years ago, from meeting to meeting and a seminar to seminar, preaching and its benefits, and I think almost reached a stage where there is so much greater acceptance of mediation and literally very willing to go to mediation over the courts. of change that the senior counsel talked about has almost happened. I'd like now to take the stage further, and that is so often prevalent in faith-based mediations, which is where I do a lot of training. And the culture of change you're talking about is contrasted with the ethical culture of mediation. Now, what does this mean? Let me give you two real-life scenarios of cases, one before me, one before a colleague of mine in Canada. So the husband and wife, a dispute, have come before us, before me. And after a long mediation, we're very close to resolving the dispute, hopefully an MSA, a mediation settlement agreement done. At the end, just before settlement, the husband says, I'm prepared to offer her $100,000, but do not communicate that to her. And you know, as a mediator, everything said is confidential. You cannot communicate if the party doesn't want it communicated. I said, all right, you must have a good reason for not communicating. He says, yes, I just want, this is only for your information. Can you bring an offer from her? See if she is willing to offer. So I go to the wife in a separate room during the course of exploration of the parties. And in my exploration, I'm cutting a long story short. In my exploration with the wife, she says, I'm prepared to accept $80,000. I said, would you like me to communicate that? And she says, yes, communicate the offer. Now you got the background. Here is another scenario. I'm not telling you, I'm going to relate this to the ethic culture, which is my subject that I want to try and talk about. And then at the end of it, you will see how the two, where the connection is. So in another scenario, before a colleague of mine, two disputing partners, commercial dispute, where we finally managed to settle the dispute at $100,000. Party A is supposed to pay to party B $100,000 at the end of the month. We're now at the beginning of the month. So it says to me in a private exploration that, look, if this guy is prepared to pay me $75,000, but on Monday, not at the end of the month, I'm prepared to sign an agreement for that. The other side in a private exploration says to me, I'm prepared to accept $90,000, 10% discount, if he agrees to an earlier payment. Now, there is an ethical dilemma here for the mediator. And there are also examples of ethical dilemmas from the party's point of view, where a party does not disclose a certain fact, where a party deliberately hides some important information that negatively impacts on the other party, whether it's a partner in business, whether it's a spouse, whether it's related to a child. And there are many, many ethical dilemmas everywhere. So our sense of mediation in a faith-based mediation is completely opposed to a commercial mediation that you will do in the court-annexed process that we have, where a mediator sticks to his role. He is bound by confidentiality, which is the cornerstone of mediation. He is neutral, he is impartial, he is not supposed to favor anyone, he is not supposed to take his role beyond facilitation, his job simply is to facilitate the two parties to come up with their own agreement. He doesn't influence, he doesn't advise, he doesn't say anything. In a faith-based mediation that I belong to, we try and develop an ethical culture of mediation where we go a step further in trying to inculcate into the parties right from the beginning and much later, and especially during exploration stage, that this is parties who are part of a common humanity, hiding to them that we were all born from one soul and we became many souls and we're part of their common humanity. And so we must look at mediation from a totally different concept. And the culture of ethical culture of mediation we encourage is to let the parties understand what are really universal principles of ethics. And these are things of integrity, honesty, a good sense of collaborative engagement, fairness, equity, all those kinds of things, moral reasoning. And most importantly, we believe there are two major concepts that we believe guide mediations. And one is what I call the bandaging of the wounds. Parties come before you because they are injured, they're really in a bad state, they're hurting, that's why they're there. They are hurting, and some of these are very, very difficult situations, especially family situations. And one of your attempts in a faith-based mediation is to bandage the wounds, the process of healing. And how do you do that? And the second notion is the continuation of a good relationship between the parties, because the relationships have broken down. And one reason we believe they are before you and not before a court is because they want this relationship to continue. Because they could be in a court and the relationships will be wrecked. A judge is not, a judge will be cold-hearted, making a decision based on the facts before him. It's not his business to know what happens after. He doesn't care what happens after. That's his business. One party will be happy, another party will be unhappy and could even be devastated. But that's not the business of the judge, because a court is not a court of fairness. I mean, a court of equity, it's a court of justice. And it doesn't matter what happens to the parties. That's why the importance of mediation, that hopefully the family's relationship will continue. So with this background, you now go back to the scenarios I posted here. They're a husband and wife situation. Clearly, one of the parties, especially the wife, if I communicate her offer of acceptance at $80,000, I know from my own ethical principle that she's going to be losing $20,000. If I go to the other side and allow the other side to pay $100,000, when I know that the wife has accepted $80,000, will I, under the same principles of ethics, doing the right thing for the husband? So what do you do? And in a faith-based mediation, we go much further than a mediator would ordinary mediation. And we would explore the situation much further, asking each of the parties in their own little rooms, separate rooms, or what we call caucusing separately, asking the parties, what do you believe is fair? Is this fair? Is this a decent thing to do? What do you believe the risk of not being fair? I mean, those kinds of questions help you to hopefully change their mind. And I see I may have run out of time. So let me conclude by saying that ethics, a culture of ethics in mediation, is an extremely important notion, and I believe is the second stage to the mediations we are currently doing. Thank you.
Thank you, Judge. That's a very interesting dimension that I think many of us had not thought about. I want to throw that out and ask you, Senior Counsel, how much of that can we bring into court annexed mediation, into the various ADR committees that you currently chair? Is there room to make mediation more and pick up some of those values and some of those principles that Judge was talking about?
Yes, certainly. I think that when you sit on both sides, as counsel, as a user, as mediator, you recognize that in certain ways, the principles that we are taught in mediation school can be superficial because they don't go to the lengths to which Judge says. Certainly, as mediators, you practice integrity in the sense that you don't deceive any of the parties, you don't disclose confidential information, and so on and so forth. But I want to say that there gets to a point in your practice as a mediator, and I practice as a mediator in the commercial space, let me say. The family space scares me. But also I chair the Sports Disputes Tribunal, and we do a lot of mediation there as well. And I have found that it is no longer possible as a mediator merely to shuttle information from one party to another. My honest view today is that as a mediator, they must get to a point where you begin to try to influence the outcome in a positive way. And that's been my experience, because sometimes a mediation will fail because the mediator does not take that little additional step to say, yes, I endorse this, because that's what the parties are looking to you to do. You have to recognize that when parties come to you, especially in the setting of a court annex mediation, you are replacing the judge that they expected to find. Yeah. And so they look at you as a judicial figure. And so if you see your role as being passive, as merely passing information, being a bridge, you have to be an active bridge. And I think when you get to a certain level of mediation, then you begin to appreciate exactly what a judge is saying, the dilemmas that you're faced with, how do you resolve those dilemmas in the best interests of the parties, and how do you sleep at night, you know, because you have a conscience too. And you have to wake up in the morning and undertake the next mediation faced with the same dilemma, and you've got to find your true north. So I think that I'm in agreement with what he says. Sufficient. We formulate of conduct, as you know, we've got a code of conduct for court annexed mediation. The Nairobi Center has a code of conduct, but they don't go far enough because they don't, in the end, address the person of the mediator and what he or she needs to do in certain unprecedented situations. Because in unprecedented situations, it's not the code of conduct that will guide you. It is really, your beliefs, your experience, and your desire to achieve an outcome that meets the circumstances of the parties. Yeah.
Thank you. Thank you for that perspective and that insight. Desmond, and why are lawyers so afraid of this? After everything we've heard, why are lawyers resisting this, in your opinion? As a new mediator, as an advocate who's just crossed over that bridge, what motivated you to become a mediator, and how do you think we can motivate other advocates to take on this role and embrace it?
Yeah, thanks, Alim. I think, following on the footsteps of other senior people in the mediation space, like Senior Counsel John Ohaga, who have really been blazing the trail and preaching the gospel of mediation. I think what helped me is that realizing that, I'm not just a litigator, but I'm in the business of dispute resolution. So the method may change and I have to adapt to the times. And that paradigm shift then also informs how I take up the role, the advisory role to my client. And even in terms of looking at revenue, which is a big factor for many advocates, and they're seeing that there will be a loss of revenue. The advocates are then now forced, to look beyond the advocate's remuneration scale and adopt probably a value-based billing system or a time-based billing system. And when you propose that to the client and they see the value and they see what the efforts that you're making in resolving the dispute, whether it is through mediation, for instance, then it is easier for the clients, to pay whatever value it is that you're offering. So for advocates, I think it's a question of a mindset shift, and people like Senior Counsel, they started rebranding their services, so they no longer call their departments litigation departments; they call them dispute resolution departments. So we have followed suit, and I think it is a better space and a better end result for the community at large. And I would just like to chime in what Mr. Hoga talked about in terms of the mediator influencing the process of mediation. And I understand the dilemma, and I think the advocates can also play a role if they work closely with the mediator. The mediator can caucus with the advocates separately, especially if the parties have become adamant and have taken a very entrenched positions. The mediator, with the knowledge that he has already obtained from the parties, can persuade the advocates, to sell the idea or to sell an idea to their respective clients, because the parties, they are likely to have a blind spot, and it is only their advocate who can actually show them their blind spot, that if you go this way, you are not likely to succeed going forward. Yeah.
Thank you for that insight, Desmond. A final question for Your Honor before we take questions from the audience. And there's always this question at the end, but I want to ask it nonetheless. What does the future of mediation look like to you, court annexed mediation? Are we looking at a successful future, or is this something that you see perhaps being short-term or more or less eventually being dropped altogether?
Thank you very much, Alim. I see a very bright future for mediation. I see us getting to a point where it will be the most preferred dispute resolution mechanism. I see a point where we would move from even the replication model that we currently have and borrowing from the lessons that we have had, especially on the issue of the screening and the referral of the cases. I see us getting better in terms of the engagements that we have with our stakeholders. I see us getting a more buy-in from the lawyers with continuous engagements with them, especially on what are their roles, what are the responsibilities, and what are those advantages that they can actually gain out of mediation. In terms of a bigger picture of it as a dispute resolution, I'm sure you have had, if you have seen the what perhaps might have been shared out of the Chief Justice strategic plan that she launched today, is that we are now looking beyond the concept of just having the secretariats or the registries, but we'd like to leverage on the conversations that are going on in terms of the bills that we currently have. and an aspect where we can not only benefit from mediation in terms of court and for those cases that have already filed in court, but we are looking to even benefit from mediation in terms of preventing or reducing the number of cases that are coming in for us. As I mentioned, there's the bit about the proposal, the mediation rules that is because of the two bills. But the rules as we have, as have been proposed, anticipate an aspect where now we have mediation agreements have been arrived at outside court without necessarily having cases being filed in court, and the court, those agreements being filed, being recognized and being enforced like any other order or judgment upon adoption. So that will give us quite a leverage. And then if I can also mention is the conversation around ADR centers. We have taken up a bit in the judiciary now in the infrastructure master plan and the engagements that we're having with both the legislature and the executive around ADR centers being set up, either whether it will be shouldered by the national or the county governments, but just giving a forum where now space where it not necessarily must be that mediations are being done within the court premises. So with that, with the improvement in terms of the facilities, the amenities, the convenience, and just generally the setup, moving away from the current infrastructure that we already have, that I'm looking forward that would also have quite an uptake of mediation. There's also the bit that was mentioned of the multi-door aspect of mediation. It is also among the issues, among the mandates that the task force in very able hands in terms of membership is looking at, to be able to give a policy recommendation what that we can do, that even then as we look at these mediations that will be done out, is it possible for us to be able to establish a setup within the court premise that litigants can actually come to court and request to be supported mediation without necessarily having filed those cases in court? Subsequently, upon the agreements, we now get through the process, as I mentioned, on adoption, recognition, and enforcement.
Let
so
me
there's
just,
a big
I know I've also interacted with everyone here. You accredited me as unaccredited. I work with you. So what I'll do, I've seen the questions are very good. So I was instructing Alim, take all of them one, like, you know your panel. So great. Don't 30 seconds each. Don't let.
Thank you.
Stay here and do all your certificates in mediation.
Wonderful. So let's have a look at the questions now that we still have an opportunity. I think the first question, are mediation clauses and we'll go step by step and everyone can answer a question. Judge, the floor is yours.
It depends on what you mean by our mediation clauses binding upon the parties under Kenyan law. If two courting parties contract to go to mediation, of course it's binding. So I'm not sure what this question intends to really ask, but nobody can impose upon the parties to go to mediation. Court-annexed mediation is now a new experiment, which the court is saying, before we can hear you, in almost in every part of the world this is so, you must have tried mediation. It is like another procedure that the court has introduced in saying, just as there are procedures in the delivery of documents, in the exchange of documents, here is another procedure which says, go try mediation first. And yes, that is binding because the law allows that part to be binding. And of course, there is a contradiction of facts, contradiction of terms here, because on the one hand, we say mediation is totally voluntary. You can agree to a mediation or you don't agree to a mediation, voluntary. So when the court forces you to a mediation, what happens to the voluntary notion? So we see this step as another procedure, which is a compulsory procedure like other compulsory procedures relating to documentation and so forth. So the simple answer is, if two parties outside of the court system have contracted, that contract is binding. If the two parties have not contracted, nobody can force it upon them. If the two parties are in the court, then the court can insist that they go to mediation.
Thank you for that very nuanced answer. I hope that helps the audience with that. If we can move to the next question. What if the court ordered mediation fails? Can the judge have access to the position expressed by the parties during mediation? And I'll direct this one to senior counsel.
Since Mercy is very concerned with time, the answer is no. I think that's really, the point is that everything in is without prejudice. In some jurisdictions, they've tried to have judicial officers like judges conduct mediation prior to the trial, and that has floundered because the judge now has information relating to the parties without prejudice positions, unless the judge moves that case onto a new judge who would then take over the matter and hear the trial and the evidence and so on and so forth. So the answer is no.
Thank you very much, senior counsel. Let's have a look at the next question. I think this sort of relates to what you've just answered. What do you think of MedArb? And so perhaps we can go a question forward. Mediation is a consensual process. When the matters are screened for mediation, the process is not consultative. Parties are expected to attend the session, hence why they don't participate. And I'm going to allow Desmond to take this one.
I think this one is probably more suited to Honorable Kendago, but maybe I could just attempt. I think just because the matters are screened and it's not a consultative process at that stage, the fact that the mediation committee has seen it is suitable for mediation, then it behoves the advocate to at least attempt the mediation and to at least attend to the mediation session. And that is the mandatory nature of the court annexed mediation, that you must at least attend and attempt to. It's not mandatory that you actually reach a resolution, but you must at least attend the session. But I'll allow Honorable Kendago to chime in as well.
What we do to try and mitigate the approach that perhaps would have our parties have with regard to the mandatory process is we have a case management for the matters that have been referred to mediation. So we mentioned to ensure that they understand the process, they understand the expectations and the responsibilities at what would entail in terms of their lawyers. And with that, with the frequent mentions, we have been able to deal with the issue of non-compliance that when we started off was really high, and we're happy that has also come down.
Great, so that helps. I know this is where the real issue has been, is that advocates simply don't turn up for the mediation, and you end up rescheduling over and over and over. And we say it's the resistance on the part of the advocates. So it's good to know that something is being done about that. Let's take the last question, I believe, which is, when the parties are imposed a dispute resolution mechanism, is conciliation not more suited than mediation? Who would like to take this question? Judge?
So first and foremost, there is a very thin line between conciliation and mediation. There's almost no line. But I've seen different interpretations and different definitions in different parts of the world, including in faith-based mediations. So conciliation is where, before you really reach that stage of mediation, Some jurisdictions say conciliation is an attempt to bring the parties together, reconciliation, in other words, reconciliation through an informal process before you really go through the long drawn mediation process. My own faith-based organization mechanism, the process, is actually the reverse. We do a mediation, remaining completely neutral and making sure that we don't cross that line, and we let the parties, we simply facilitate the parties to make a decision. And if the parties simply cannot move at a certain point, meaning there is a deadlock, and now it is necessary to move the parties, and you've tried every possible tactic that we are taught in breaking a deadlock, you simply can't do it. Then we say you can wear your conciliation hat and start gently nudging the parties, advising the parties, and giving them guidance through reality testing. What do you believe the court will do? What do you think will happen if you don't make an agreement today? What do you believe will be the extra expense of hiring a lawyer and paying court fees if you don't settle today? How long do you believe this case will take if it goes to the court? What do you believe will be the expense that you will incur in this matter going to court? Now, those are the kind of questions which we call in our system reality testing. Will enable you to wear your conciliation hat to nudge the party. That to us is the difference. I don't know if I answered the question. The question is, when the parties are imposed a dispute resolution mechanism, is conciliation not more suited than mediation? So you've seen both sides of the definition. And yes, I think a good mediator will switch hats if and when necessary, but remain true to his professionalism, not to make decisions, not to sway the parties in any way until there is an absolute.
Lim,
Thank you, Judge.
more than enough time for this panel.
Thank you, Mercy. Thank you.
More than enough.
I'd like to thank all the panelists for coming here today for this interesting discussion on court annexed mediation, potential and possibilities. Thank you, everyone.